Good afternoon, and thank you for joining us for the talk about the recent Court of Appeal decision in Hirachand and Hirachand. I'm very pleased to be introducing Oliver Ingham, who is a very valuable member of our property and estates team in Chambers. He represented the appellant in these proceedings, led by Stephen Hawes QC from Gatehouse Chambers, with Mills and Reeve acting as the instructing solicitors. For those of you who haven't had the chance to read the judgment yet, I won't spoil it because you're going to hear it directly from the horse's mouth. Before I hand over to Oliver, I do just want to say that he is incredibly specialised in this area, and in respect of Inheritance Act claims, if there is an issue or something that arises that he doesn't already know the answer to, my advice would be to not trouble yourselves about learning it. So without much further ado, it is my privilege to welcome Oliver, and I look forward to hearing what he has to say. There will be an opportunity at the end for questions. You can put them into the chat. We have had a couple in advance, but I know that I do have a couple of issues which I'd like to chew over with Oliver. So welcome, Oliver. Thank you.
Thank you very much. Thank you. That's a wonderful introduction. Wholly undeserved, I'm sure, but very, very, very polite and lovely introduction. So yes, as I say, the Court of Appeal's decision in Hirachand and Hirachand is out, and it was released, it was handed down on the 15th of October. Just to give a very potted history and background and to explain why it is even relevant at all for anybody who's not aware. There was a first instance decision in 2020 during the pandemic called Re-H 2020, in which, for the first time, Mr. Justice Cohen in the Family Division awarded a claimant an uplift under her CFA as part of her maintenance needs when making an order under Section 2. Now, the original judgment of Mr. Justice Cohen is, of course, available on Bailey, and as I understand it, there'll be references and materials, etc., afterwards that can be requested. But to put a very long story short, it was an adult child claim made against a mother's estate. Apologies, it's an adult child claim made against her father's estate. The reason that her mother was involved at all was because it was a Section 9 claim, where there was an attempt to sever a joint tenancy over what was effectively the former matrimonial home. The reason that's relevant is because my client was joined in her capacity as a beneficiary, but of course she was also joined because she was a co-owner of her former matrimonial home. There was and as I say, there was an attempt by the claimant to recover an award from the proceeds of sale of that house by severing the joint tenancy. So that's like a potted history of the first instance proceedings. I think had they been properly defended or defended at all, then the outcome of the proceedings may have been different. The trial, I believe, was heard over one day at the very beginning of the COVID pandemic. I believe it was heard by video link. And when the claimants were addressing the court on the needs that they had for their client, they proved their case essentially in relation to the entitlement to claims an adult child. There was a request made that all or part of the CFA uplift, which the daughter had incurred in funding the litigation up to that point, be considered under Section 2 as a need. Now, this is something that the courts had considered previously. The Chancery Division had considered this question. The decision of Master Linwood in 2019, and if you've read Hirachand and Hirachand before now, you will see reference to it. But that was the key Chancery Division analysis of this question. The Chancery Division answer to the question, if you like, of whether or not a CFA uplift counts as a maintenance need was effectively no, because it amounts to an increase in damages by way of costs. It mixes up the cost regime with questions of liability. It puts claimants in an unfair position, and because it would then mean that they're the only category of claimant at all that can claim their uplift. And as I say, if you give it a quick read, there's some general reasons given as to why Master Linwood in the Chancery Division determined that it shouldn't be done. Mr. Justice Cohen considered that decision as well in his judgment, and those were the circumstances which gave rise to the appeal to the Court of Appeal. So there were effectively previously a number of grounds of appeal. We were given permission on 2 grounds. One I'm not going to be talking about particularly. You'll be able to read it in the judgment. It was in relation to reasonable adjustments insofar as video link was concerned. It's not the primary focus of this talk, although it is of interest perhaps to those who have any experience in equalities or discrimination, any of those kind of practice areas. But for sort of chancery practitioners, as it were, the interest was in what was known as ground 2, which is that Mr. Justice Cohen erred in law when he awarded the claimant her uplift from the estate. Now, again, I won't go over and over the arguments that were made at the Court of Appeal. The crux of the argument that was put on behalf of the appellant was that the decision by Mr. Justice Cohen to do this was an unlawful circumvention of Section 58A of the Courts and Legal Services Act 1990. That is the statute, as it were, that prohibits the court from ordering parties on an inter-parties basis from ordering a unsuccessful parties to pay an opponent's CFA uplift. So we said it was amounted to a circumvention of that provision. And then there were also other ancillary arguments to do with the fact that we say that it undermines entirely, effectively, the civil cost regime, because Part 36 can't fit into it. If you read the first instance judgment of Mr. Justice Cohen, you will see that there is some real struggle in terms of the question of how it is resolved, where you have a CFA, but you ask for the uplift before you know the outcome of the decision. And of course, the uplift is a question of costs. And there's a lot of grappling in the first instance judgment, which demonstrates that tension. And that was what the Court of Appeal was considering in this case. Now, cut a long story short, the appellant lost. The rough and ready explanation or basis for what the court said was that in some but not all cases, it is permissible for the court to award 75 Act claimant their uplift out of an estate in certain circumstances. And that is, of course, now the established position. There was previously the tension between the Chancery case and the Family Division case. That has been resolved by the Court of Appeal. So we said in the invitation that was sent out that we would cover a number of issues. Before I do that, I should also say that Lydia mentioned I was led by Breeze Stevens Hall Queen's Counsel. She is doing similarly a webinar on the 25th of this month, and I would fundamentally encourage you to go and join that and watch that as well, because of course that is on the same topic. I believe she's also joined by Cameron Stocks, who is a member of the probate team at Gatehouse, formerly known as Hardwick Chambers. So I would encourage everybody to join that webinar as well, and hear from Ms. Hall, Queen's Counsel, who led me. But the focus of this talk really is on quite practical questions, because the Court of Appeal has said what it said and we are where we are. And there were 7 questions that I wanted to look at assuming that this Court of Appeal judgment stays in place and this becomes standard practice. This becomes the law effectively. The first one was, what new advice now needs to be given to clients litigating 75 Act claims, both at the outset and during the claims? I think it's important to emphasize because of the fact that I think it has been reasonably well known that Re-H was being appealed, there has been a slight period of uncertainty in the courts about whether or not awards can be made for provision for CFA uplifts. That's of course now settled at appeal. I think it will be clear, or there will be some indication, if there is any intention on anybody's part to appeal that decision to the Supreme Court. If that happens, it may be the question continues to be unclear, but for now there is an authoritative, of course, Court of Appeal judgment which sets out the position, and I think it's justified. That justifies telling, first of all, clients who have CFAs and who are asking for CFAs at the beginning that there's been a recent change in the law regarding the recoverability of the uplift, but also, of course, the defendants to the claims, because they are the eventual ones who will effectively be ordered to pay it. I'm using shorthand there. I say ordered to pay it. Obviously, the estate's ordered to pay it, but I think it all comes out of the same pot. So it is imperative, I think, at the outset with clients who are planning on using CFAs in the 1975 Act, that if they are going to have litigation funded this way, that yes, there is, of course, a prospect that at the end of your case, the court may award you part of the uplift. And I think I would say the decision says all or part. Of course, when claims are put, it will be put on the basis of all or part of the CFA uplift. Of course, the claimant will ask for all of it, but the reality is it's going to be a part of it in practical terms. And it's important to advise your client that the Court of Appeal decision and what Lady Justice King says does not mean that in any and all cases where a claimant wins and there's a CFA, that there will be a contribution to an uplift. The decision leaves judges more than enough room not to award an uplift if they do not wish to do so. And the reason I say that is because, for example, at paragraph 59 of the judgment, Lady Justice King gives what is quite an open invitation to perhaps judiciary below, that of course it will not be in every case that it's appropriate to make an order of that nature. So it's not appropriate to refer to the case as being authority for the proposition that claimants are now entitled to CFA uplifts. It's rather authority for the prospect that they may, in some cases, be entitled to recover uplifts. I think the advice previously, prior to Re-H in 2020, would always, of course, have been, you're never entitled. Well, I don't know. It may have been that this point has arisen in litigation and it's never come to the height of being reported. I suspect it hasn't, but the previous advice, of course, would have been to advise claimants that they cannot do it. That advice, obviously, is no longer correct. So that's the first question that I put in the invitation. The new advice is essentially that they can do it. There's a chance that they can get it. Not everybody gets it. The judge has quite a lot of discretion about whether it's awarded at all. That brings me on to the second question, which is recovering the claimant's CFA uplift from the estate and when and how this should be done in view of this decision. Now, I said that there was quite a lot of latitude in the judgment. Part of that latitude comes because there is a list, effectively, of steps which I think the parties are expected to take in future if they want to do this. So if you are a claimant for example, if you are a probate team who specialises, I don't know, in claimant-led 75 Act work, it would be expected that there should be evidence on the seeking of other means to fund the claim. It should be demonstrated that there is no other means, or at least an attempt should be made to demonstrate that there are no other reasonable means by which the litigation could be funded. I would suggest in particular that that might include writing to the estate if the case involves an estate which is large enough and it's a specific type of claim, maybe a cohabitant claim or a spousal claim, where there might be clear merits. I would suggest that that includes writing to the estate to ask perhaps for a payment on account when bringing a claim, if there's reception to that on the other side. In any event, there should be evidence, whether it is done in a different witness statement or not, whether it is done as part of the claimant's general evidence that is put in with the Part A claim form. I don't think really matters, but it is important, I won't say vital, if this is going to be done, that the evidence is there to justify the CFA, meaning that it isn't enough to sort of turn up and then at trial assert that, of course, the client was unable to afford the litigation. Then there needs to be specific evidence that they've given consideration to the question. And I think that I would say that the solicitors have given consideration to the question. So I think I would be advising solicitors in future that there should be probably a specific statement from the claimant. There's no harm in it being done as a separate witness statement which deals specifically with funding. And it may be that the solicitor is able to give evidence as well, in as far as it is appropriate to do, of course, in the usual way. So that's again, in terms of recovering the uplift, it is going to be challenged, and there's going to be scrutiny applied to whether it was required, the basis on which it was required, etc. Now, there are some practical issues which arise, I say, from the Court of Appeal's judgment, and these may or may not arise in future litigation, and these may or may not be ironed out. One of the questions that I have had myself and I have been asked following the judgment is whether or not it means that the CFA, the document, is essentially disclosable because it's part of the proceedings. For example, you'll have seen that Lady Justice King made reference to the analogy between the CFA uplift and a debt. Obviously, we know, of course, if a debt was being claimed in a 75 Act claim as part of the claimant's financial picture, there would, of course, be documentary evidence and support. With the CFA uplift, if that's essentially a liability that has to be paid as well, what does that mean? Does that mean that the CFA has to be disclosed? And the answer to that is I don't know. My advice at present to those that I'm instructed by would be that, well, not my advice. I'll give actually my view on what the answer to that question is. I think that personally, following the judgment and following the reasoning of Lady Justice King, that it necessarily must be. I think there's going to have to be consideration given in future to how that interplays with the question of privilege, because, of course, a major part of the CFA is the description of the uplift, the percentage that's applied, etc., what the justification for it is. And usually that justification includes almost effectively a little, I won't say advice on the merits of the claim, but it includes quite clear legal text about the basis, the justification for the percentage in question. And I'm sure that those who practice in this area and who use claimant CFAs on a regular basis, I'm sure that you will know what I mean when I'm talking about this description. Because, of course, obviously, up until this point in time, that would all be privileged. And it may be that there is disclosure of the fact that a claimant's on a CFA, but there'd be no question at all of the document actually being disclosed. And as I say, I suspect, or I wonder if this is an issue that is going to arise specifically because it may be that the court's going to have to resolve to what extent is the defendant entitled to get disclosure of the CFA, and if they are, what are they entitled to? Looking at a common sense answer to that question, it may be that you're entitled to see the CFA document subject to redactions. Again, it's not immediately clear, but it's one of the wrinkles that arises out of this question. And again, I say that's another example of the wrinkles that happen when what is fundamentally a cost question is dealt with at the trial phase. So that covers, I think, the fourth question especially, which is what new procedural steps now need to be undertaken when issuing and litigating 75 Act claims. I would say by procedural, again, it's appropriate to have a separate, I think, witness statement from client, from the solicitor, which explains specifically what the position is with the uplift. And again, it could probably be done in their own evidence, that there might be some value in the separation between the two. It will entirely depend on the context. And I would also say that it's rare to see defendant CFAs. I don't think I've come across a defendant CFA in a 75 Act claim. There's no real reason in principle why that shouldn't hold true as well. So when they're putting in their response, again, it's less likely to arise because, of course, in that situation, the defendants will be the beneficiaries, will be entitled to recover from the estate. But you do see reference sometimes to alternative funding models for defendants, and it's an interesting question as to how that would work, because of course they won't be entitled to get it from the claimant personally. It may be something that arises where you have multiple defendants with different stances, perhaps, but I think I'll leave that there. There's a lot of problems that arise out of the situation where defendants have different positions, particularly in this context where there are different funding models. Now, I posited as to whether or not there was necessarily a need to revisit the approach to ADR in 75 Act claims. Obviously, this decision is a positive one from the perspective of a lawyer who is advising a claimant in 75 Act proceedings. It gives effectively a very potent weapon to be used, if that's the right word, at the ADR stage, talking particularly about mediation. This is where really I think it's the defendant's positions that need to be considered most. Of course, if you're representing the claimant, the fact that there is the risk of now not only getting the award, but also getting part of the CFA uplift, potentially all of it in some cases, that's something, of course, that is going to be used to your advantage if you're in a mediation situation. Perhaps even in a nuisance claim, where you have perhaps, by nuisance claim, I mean one which is less meritorious, but still has a basis in fact and ground. So you get some adult child claims, for example, that are in relation to smaller estates where there is a loose basis on which a claim might succeed, but ultimately the merits might be quite low, and they can be relatively common. And this obviously, and even in those situations, that might provide a reasonably potent weapon in relation to trying to get some kind of settlement out of the other side. Certainly in larger litigation, it definitely will. And in a way, the bigger the case and the bigger the amount of money involved, the more the more damaging the point's going to be. So it's something that needs to specifically be considered at the stage of mediation with the clients. It's something they will need to be reminded of, particularly defendants, because of course there is always a point in 1975 Act claims, especially when you're representing defendants, where there has to be a discussion in 90% of cases about settlement and getting a settlement. There obviously has to be a discussion with the defendants about the risks that they're taking. Again, in certain categories of claim, I mentioned cohabitants and spouses in particular, there may be scenarios where the claimant is going to succeed in getting something. So effectively, the claimant is going to be the winner of the litigation. And again, at that point, a conversation obviously really needs to be had with the defendants that the uplift element adds an extra reason for them to settle proceedings early. And again, at a mediation, that might be something that will be deployed insofar as advising clients. So that's essentially what I wanted to say about the practical aspects in terms of moving forward for claims, and sort of practical considerations that I've thought of since the decision has come out. I wanted to delve a little bit into whether or not it changes or otherwise widens the definition of maintenance, because of course you'll be aware this was an adult child claim, so it was a claimant who is limited to reasonable financial provision for the maintenance, for their maintenance. And of course, the Court of Appeal has said that a CFA uplift counts as part of the maintenance. I don't think it does actually, because it's obviously a very discrete particular issue. The CFA uplift arises specifically in relation to the litigation. I don't think it means that there is scope there to widen out yet more, perhaps, the meaning of what can be included within the definition of a maintenance need. I think it's really one of those cases that applies to quite a discrete set of circumstances. So there was a further final point which came out of the decision, which is relevant to the 1975 Act specifically. It's actually relevant in all litigation, but specifically the appeal judgment is of course directed at litigants in Part 8 1975 Act proceedings. There's a question of what it means to be debarred from defending a 1975 Act claim. This is a slight curiosity that arose out of the fact that the claimant was predominantly or nearly predominantly unrepresented, which was that there were a number of orders made in the family division for various things to be done. Of course, she was debarred from defending for various reasons. Essentially, there was just non-compliance, leading up to and including an unless order, which was in terms that unless X, the claimant will be debarred from defending the 75 Act claim. It's a slightly curious phrase because, of course, 1975 Act claims are a rather odd species of litigation in that they're claims brought by the claimant against an estate for an order making provision for their needs. And yes, okay, there are the beneficiaries and the executor listed as the defendants. We know that they don't have to do anything at all. They don't have to defend the claim. They don't have to do anything. There's no burden on the defendants if they choose not to positively advance a case based on their own needs. So it's a slightly odd phrase, but I think one knows what it means. What does it mean to be debarred from defending, or struck out, if you like, if you're a defendant of a 1975 Act claim? Now, again, within the scope of Part 8, the judgment's quite clear that a debarring order means what it says. And I think, as I say, this arises in the context of Ground 1, if anybody's specifically interested in looking at the relevant part of the judgment. There were two different approaches previously at High Court level as to what a defendant could do in civil litigation if they were debarred from defending or struck out. There was approach A, which was effectively, no, they cannot do anything at all. If you are a defendant who has been debarred from defending or struck out, you are not entitled to do anything, up to and including arguing about costs. You can come and sit in the public gallery, essentially. There was another approach at High Court level, which was very much different, which indicated that a defendant in those situations could still attend, make submissions potentially, cross-examine the claimant's witnesses, argue about costs, etc. They just couldn't put forward their own positive defense, and they certainly weren't allowed to rely on any evidence. And those two approaches, I suppose, are lying conflict, obvious conflict with one another. That the Court of Appeal, I think it's fair to say, reasonably firmly resolved that. The use of the phrase used in the judgment is debarring order means what it says, and that will ordinarily mean debarred from doing pretty much everything up to and including the discussion of costs. And I would say that that probably holds good for any civil claim generally, but as I say, I think it's important to have a detailed look at the judgment to grab some of the nuance, because of course I'm trying to give it a potted summary and not really doing it justice in terms of a lot of the nuances. But yes, if there is a claimant, if there's a defendant who's debarred from defending, they're not really allowed to do anything. I happen to think that under Part 8, there is, of course, the provision if the reason for debarring is because of non-compliance. So it might be that you have a situation where a defendant just doesn't do anything at all in relation to a claim. They're just not bothered. And then halfway through the litigation, they change their mind. And of course, they're in serial, they'll certainly be in breach of CPR 8.5 in relation to evidence. They may or may not be in breach of certain orders. There is always, of course, going to be the opportunity at that point to make an application. And obviously it goes without saying, if there are scenarios and situations in which you have clients rather in that position, the application obviously has to be made urgently, explaining the change of position and explaining why there is now an interest in participating. I am hazarding a guess that in most proceedings, the court is going to be relatively sympathetic to allowing defendants who are in that scenario to have participation rights. Obviously, of course, it's going to vary depending on the scenario. If there's active fault and they've already had a chance various times, which is more of a Hirachand type scenario, then of course it's going to be a lot more difficult, because there's going to be a lot more explaining to do in terms of why particular orders weren't followed. But if it's just a straightforward case of a defendant doing nothing at all, and then for whatever reason changing their position and wanting to start defending the claim, perhaps even at a late stage, there may be cost consequences. Those may fall on the estate or indeed the person themselves. I happen to think that it's probably likely that they will generally, if they have some logic or reason to the way in which they're behaving, be permitted to join the proceedings for the purpose of defending them. So there are two different things there. There's the debarring order, which I think isn't language you usually see in 1975 Act claims at all. If we do happen to see it again, then we have a very clear understanding of what it means. Obviously, in that situation, an issue needs to be taken and an application needs to be made within relation to the specific order which prevents the defendant from participating. But in general terms, you may have situations where the defendant just doesn't do anything, and then of course it's Part 8 that you can have recourse to try and remedy that position. And the relief from sanctions type considerations are, of course, going to dominate that analysis. So there's a final point that I wanted to address generally, just in terms of the limits that the decision has insofar as the claimants are concerned. What are the limits of the decision? There are a number of things that I think have to be borne in mind. It should not be considered as effectively a license to recover CFA uplifts. As I say, the judgment of Lady Justice King is nuanced and detailed in relation to the reasoning given and the rationale given. Following that, there is, of course, a practical summary, which is made very clear that it's not going to be appropriate for every case. It is left incredibly open, and that is to such an extent that there is great scope at trial stage for counsel to make arguments about whether it's appropriate in that situation. And that is going to, I believe, be an effectively open-ended question, having regard to probably all of the circumstances at that time. So it should not in any way be seen as a license effectively to recover a CFA uplift. I would still suggest that it would be a good idea for claimants to remain risk averse and assume or proceed on the basis that they're not going to recover it, because of course the court at the end has enough room not to award it if it thinks that to do so is unjust, or if the judge just doesn't want to for any particular reason, or any particular factor arises during the trial which gives the judge a reason not to do it. Of course, like all litigation, 1975 Act claims are, I think, in a different category in terms of the risks that they pose to the parties involved. There's always risk in litigation, but 1975 Act litigation is particularly risky just because of the wide discretion that the court has and the open-ended nature of the Act, many of the definitions used, etc. So I think it would still be incumbent on claimants who are being sensible in any event to proceed on the basis that they're not, proceed and plan on the basis that they're not going to get the uplift. Obviously, if it is recovered, that's wonderful, and of course will be a successful day in court. And I think it's better, of course, to proceed on that basis rather than assuming that they can get it back. So in relation to the impacts of the decision from a practical perspective as opposed to academic, and as I say, there are other talks which may deal in more detail with that side of things. It is not in any way an indication that in every case where there is a CFA funded claimant that the award is going to be made and that the call is going to be made in their favour. So as I say, that's really just a summary. Of course, we've only had a relatively short period of time, coming up to time very shortly. There's an opportunity to ask questions specifically. I'm happy to answer questions about anything in particular. So yes, Lydia, I think I'll pass back over to you at that point.
You say that, and of course, there's always technology. Thank you, Oliver. Right, if I just may sum up, and you can correct me if I'm incorrect about the narrative I take away from Hirachand. So first of all, Court of Appeal have reminded us that this, the 75 Act is a statute about needs. The second point to take away, from what you've used terminology in respect of it being nuanced and discretions, that this remains a fact-specific point. It works to be respondent in Hirachand. That does not necessarily equate to it working across the board, and in particular in that regard.
Yes, absolutely.
The value of the estate will, to a large extent, dictate how the court deals with this. And I think it was a comment from Miss Justice Cohen in Riach, the first instance decision, demarcating between Riach and Clark, that the values of the estates may have led to...
Yes, he did make that point.
So the second point is that it remains fact specific. The third point is that, you know, the Court of Appeal has said this is how it is until the Supreme Court say otherwise. The principle of it, fine. The devil, of course, is in the detail, and the problem is with the practical application of it. And what I couldn't see in the judgment, and you've used the phrase left it open or open-ended, what I couldn't see in the judgment was Lady Justice King saying, this is how you deal with a Part 36 offer, or when it comes into a CFA woman, of course, we don't know what the amount of cost is. So the practical considerations, and at this point in time, you're inviting claimants and defendants to consider disclosure of CFAs. And I think on my personal note, I would be saying at this point, 2 points. The fact of the CFA can be disclosed, the percentage uplift can be disclosed, the rest of it remains privileged unless somebody wants to give me a good argument as to why it shouldn't be. I think the one thing that came out for me, and because within the judgment itself, there's a lot of discussion and correlation about how the Matrimonial Causes Act has a very open position, because every spouse's civil partners go into the proceedings knowing what everybody's costs are, and it's an open basis. And I'm just wondering whether that's the way that we'll have to go, particularly with spousal claims, civil partner claims, and potentially cohabitant claims, is that actually it's going to have to encourage more open offers being put forward as opposed to without prejudice, so that the judge dealing with it knows that when somebody says they've got these needs, they can see directly, cards on the table, what that is. And just the final point to pick up was in respect of the debarring order. I think you're right. I agree that this is a different type of litigation. This is the courts being able to drive a coach and horses through a testator's intention. This is a defendant having to sing for their supper, essentially. And I think my view would be that if someone's debarred from tendering their own evidence and putting a positive case, I think it goes too far to prevent them to be able to make submissions in respect of costs, because what's the obligation on the claimant to be even-handed in their submissions? So they're just the points I pick up on. There were a couple of questions which were sent through in advance, and of course they just go directly to the heart of your practical advice. The first is, well, it's in 3 parts. If success fees are recoverable as part of the award, how does the defendant appropriately pitch the offer, for Part 36? Are Calder Bank offers therefore the only viable option in 75 Act proceedings? And what about after the event insurance and cost shortfall? I think my reaction to all 3 questions would be, well, indeed. I don't know what
I was going to say. Yes. So in relation to that first one, this was something which was covered in quite a lot of detail during oral submissions, which, if anybody is really interested, are available on YouTube. You can, of course, see the full oral submissions in relation to this, and there was quite a lot of discussion on this point as to, well, how on earth does one fit this analysis into CPR Part 36. In my respectful view, I think there isn't a way of doing it, because, of course, Part 36 is designed to be its own creature. And as I say, you may have a situation where a claimant is given something. So, you might have a cohabitant claimant, for example, where they are awarded, say, 100,000, and they, in a £1 million estate, they don't do very well, perhaps, and they've been made an offer of 150 in Part 36, and the judge doesn't know about that at the stage in which they're considering whether or not to grant the uplift on the CFA. Now, the court, as you say, Lydia, it purports to deal with the consequences insofar as Part 36 are concerned. If you want to read specifically what's said, there's some mention of it at paragraph 52. Essentially, the court doesn't address directly that issue head on in terms of, well, what happens, what is the position. There is some commentary at commentary at paragraph 36, where Her Ladyship is referring to another decision called Lillyman and Lillyman, before Mr. Justice Briggs, where he had both counsel concede before him that, of course, he wasn't able to consider CFA uplifts and he wasn't able to consider costs and offers before making the order. Lillyman, it was from 2012, and it was a set of litigation where there were quite significant cost consequences as a result of the parties' ADR behaviour. So it's an interesting reading, just as a side note. But Mr. Justice Briggs identifies this sort of tension where, you know, it's you don't know what the costs are and who's going to win the cost before you know who the winner is. And you know, this idea that you should revisit in any way the decision on who the winner is and to what extent once you know about the costs is an anathema to civil litigation entirely. There is some treatment of this issue in Her Ladyship's judgment at paragraph 63. And essentially what Her Ladyship says is this: so the civil litigation costs regime, unlike the approach in financial remedy cases, means that there is a potential for a situation where a claimant is awarded a contribution to her CFA uplift, but is subsequently ordered to pay the defendant's costs of the claim. For example, where the claimant won overall, but they failed to beat a Part 36 offer. The only guidance is given after that. It says, I note, however, this is less likely to be of a risk than might be first thought, because under many CFAs, the claimant is obliged to accept any reasonable settlement offer or an offer above a specified threshold. Conversely, a success fee is not frequently payable in the event that the claimant, on advice, rejects a Part 36 offer. Now, again, the difficulty with all due deference and respect to Lady Justice King in this instance is, of course, that there's a view to be taken about that as a practical point, first of all. And second of all, there's a view to be taken about when and where you might be having these arguments, e.g. in the cost stage, as we're used to as chancery or civil practitioners, or indeed at the stage where you're fighting over who gets what and how much. Lydia, you mentioned the point where you said, does this decision mean that we need to start effectively seeing 75 Act claims as being akin to financial remedies? I think the answer is no, because it's very clear that this does not change the fact that the CPR, I think in all but one respect, applies to 1975 Act claims, but it does make it incredibly difficult to do Part 36 offers. The practical question was, well, what do you do in this situation then? My advice is twofold. First of all, that in relation to any Part 36 offer made by a claimant, made by a defendant, I think it's important that the Part 36 offer is phrased in terms that it is a legacy, e.g. that what's being offered is X amount of money, as if it were awarded under Section 2 as an award. And I think it's important to put that in there, because it's vital to remember with Part 36 that it has specific consequences. And if you just put a number on, and I've seen solicitors do this all of the time, if you just put a number on, for example, if the defendant says we'll settle for 100,000, you know, you might have a few defendants and perhaps a professional executor. If they all accept that, I mean, that creates a money judgment for £100,000. It might be, and indeed I've had some practical experience with undoing the consequences of this before. It might be that there are solutions to be found later down the line, but it's worth remembering that when you're making the Part 36 offer, the claimant at court on their best ever day is getting an order under Section 2. They're not getting a money judgment in the same way that they might be if they were in a personal injury claim, or indeed any other type of civil claim. So first of all, it should be, in my view, importantly, phrased in those terms, that the offer is being made for X amount of money, as a legacy, or as if it were written into the will. There's specific wording that can be used to try and just head that off. Incidentally, reversely, there's also been situations in which offers have been found not to be beaten on that point, and that was a point that I took once, which was that the offer hadn't been beaten because it just said X amount on it. And I said, well, she's not entitled to a money judgment. What she's entitled to is an order under Section 2, which is totally different. And we were successful on that point. So that's the first thing. I think here, you can't really do anything other than consider it in the amount that's being offered. I don't think it's wise to specifically mention different parts of an offer and break it down into smaller parts, because there's always difficulty with Part 36 and 75 Act claims anyway, in terms of working out whether they've been beaten or not, particularly if you've got other criteria that your clients want to put in there. I would just say it's something to be taken account of when you're valuing the Part 36 offer that's been made, essentially. I don't think there's anything specific that needs to be done, or indeed can be done. And this judgment does not mean that the judge is allowed to see the Part 36 offer in advance. I should make that clear, that it doesn't create the judgment. It's not a justification, if you like, for telling the judge about Part 36 offers in advance.
Thank you. We are almost out of time. There was a further question came through in advance, and I've answered a couple on the chat, Q&A, as I could as we were going through, but there are some extant questions. I think,
yeah, of course.
If I just take the one that came in advance out of fairness, because that came in first,
yes, of course,
leave it at that, and then anything existing within the
I'll try and give shorter answers as well. I'm sorry.
I'll just mute you in the future. So the last question I'd like to put to you then is, it was more generic, and it's about the drafting process. Is there anything in addition that one can put into the drafting or preparation of wills for clients treating children unequally or excluding one or other as a result of Ray H? So it's a more broad question, essentially. Yes. If I read it correctly, is there anything further that a draftsman can be doing for clients to bat off in the future, other than the usual forfeiture clause and all the enforceability of that, etc.?
Yeah, I don't see, again, anything can be put in the will that the client wishes to go in there, insofar as commentary. There's no reason not to mention it specifically if there is a description or it's a good word, batting off clause. You may have the forfeiture, of course, but there may be, a batting off clause which explains the decision, explains the rationale, and I don't think that there isn't anything specific other than maybe mentioning that you've taken into account the fact that this may lead to litigation. Perhaps mention the judgment. I don't know. I think probably the answer is no. But I mean, of course, you can put whatever you want in, and perhaps it doesn't hurt to have a reference to considerations about this. And incidentally, while just on that point, in terms of will drafters and advice that's given around that process, this is something I think that should be raised with testators specifically. Now, it's normally raised, of course, because you have the discussion with them when the sort of right to spite type scenario is coming up. And I think it would be worth explaining to them, do they understand that the consequences are X, Y, Z? There can be Inheritance Act claims. And, you can even say, do you understand as well that not only does that mean that they can bring litigation that's very expensive against the estate, but they might be able to do it in circumstances where lawyers take their case on a CFA, no win, no fee, and the reward for that, if you like, the uplift, may fall on your estate. So I suppose it's another point to consider if you're a will drafter and you are advising clients at the point of drafting. And I should say, from a perspective of counsel at the end of the process, those kind of things in will files are really helpful, and they are really good for answering these types of questions right at the end.
Yeah.
Because of course you have the record.
Yes, thank you. So I'm going to have to say two things to close, because I like to have the final word. The first is just on that very specific point, when you are getting in touch with clients and asking them if they want to update their wills, that's also a good time to ask them to confirm that their wishes remain the same, because of course, when it comes to the question of estrangement, for example, somebody who may have excluded a child in 2002, that may not be the situation prevails 18 years later, they just didn't get round to it. And under section 3(1)(g) of the Inheritance Act, that is it's another factor that the court can take into account. And second of all, just to close on a semi-personal note, when I last did one of these talks, somebody asked me, well, how many of the wills that come across my desk are contentious? To which the answer is, well, all of them. That's what we have to do at the end of the process. So
yes,
thank you very much, Oliver. Thank you, everybody who was on the call to listen. Any questions? We'll try and get around to them if we can, but you should always feel free to get in touch with us directly. Thanks, Delphine, for sorting out, and I wish you all a safe onward journey. Take care.
Thank you very much for joining.